So today, the Supreme Court issued a 9-0 unanimous decision that redefines when police can enter your home without a warrant. This ruling affects every homeowner in America, especially gun owners who need to understand their Fourth Amendment protections. Hit that subscribe button right now, because what I'm about to explain could happen at your front door tomorrow. The immediate ruling and why it matters. On review, the Supreme Court found that police officers had an objectively reasonable basis to enter Trevor Case's home without a warrant, and therefore all evidence discovered inside should not be suppressed. This means that across all 50 states, law enforcement now has clarified authority to enter your home without judicial oversight in emergency situations. We're talking about a decision that affects every homeowner, every gun owner, and frankly, every American who values the sanctity of their private residence under the Fourth Amendment. Now, the facts around this case reveal a deeply troubling scenario that played out in Montana. Trevor Case's ex-girlfriend called police, claiming she had a bad feeling after speaking with him on the phone. She told officers she thought she heard something about a firearm and believed he might harm himself or potentially shoot responding officers. 4 police officers arrived at Case's home along with the ex-girlfriend. When they got there, she admitted she couldn't really remember exactly what he had said, just that she had this bad feeling about the situation. The officers spent 40 minutes outside the residence. They knocked on doors, shined flashlights through windows, and called out for Case repeatedly. They peered through windows and spotted what appeared to be an empty handgun holster and a notepad. Case never responded to any of their attempts at contact. But what happened next in the legal system is what brought this case all the way to the Supreme Court. The Fourth Amendment Showdown. Let me walk you through the constitutional battle that unfolded after Trevor Case was shot and arrested in his own home. Case was charged and convicted of multiple criminal offenses. However, his legal team argued that the warrantless entry into his home violated his Fourth Amendment rights, which protect against unreasonable searches and seizures. They demanded that the handgun found in a laundry basket in his bedroom and all other evidence be suppressed because the officers had no legal right to be inside his house in the first place. The Fourth Amendment is one of the most fundamental protections in the Bill of Rights. It states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. For over 200 years, American courts have recognized that your home is your castle. Law enforcement generally needs a warrant signed by a judge based on probable cause before they can enter your private residence. However, courts have carved out narrow exceptions to the warrant requirement over the years. One of those exceptions is called the emergency aid doctrine, or community caretaking function. This doctrine allows police to enter a home without a warrant if they reasonably believe someone inside is in imminent danger or seriously injured and needs immediate help. And this is where the Montana Supreme Court made a critical error that led to today's unanimous reversal. The Montana mistake. The Montana Supreme Court ruled 4-3 in favor of the state, upholding Case's conviction and allowing the evidence to stand. But here's the problem. They used the wrong legal standard to reach that conclusion. Instead of applying the test established by prior U.S. Supreme Court precedent, the Montana court appeared to apply a much lower threshold called reasonable suspicion. This is the same standard police use for brief investigative stops on the street, not for entering someone's home without a warrant. Reasonable suspicion is a relatively low bar. It means officers only need specific facts that would lead a reasonable person to suspect criminal activity or danger might be present. It's less demanding than probable cause, which requires a higher degree of certainty. By using reasonable suspicion as the standard for warrantless home entries in emergencies, the Montana Supreme Court essentially made it much easier for law enforcement to enter homes without judicial approval. The U.S. Supreme Court had already established the correct standard years earlier in a case called Brigham City v. Stewart. In that 2006 decision, the court held unanimously that officers may enter a home without a warrant when they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury, So here's what you need to ask yourself. What does objectively reasonable actually mean when armed officers are standing outside your home deciding whether to come inside without permission? The oral arguments and predictions. After listening to the oral arguments earlier this year, legal experts predicted that this case would hinge entirely on whether the Montana Supreme Court properly applied the Brigham City Standard. During those arguments, the justices pressed both sides on what objectively reasonable means in practice, and how it differs from reasonable suspicion and probable cause. Case's attorneys argued that the officers lacked sufficient justification because the ex-girlfriend's report was vague and unreliable. She couldn't remember what Case actually said, admitted she just had a bad feeling, and there was no evidence of an actual emergency occurring inside the home. They pointed out that Case had every right to ignore police knocking on his door, and that his silence couldn't be used as evidence of danger. The state's attorneys countered that officers had multiple concerning factors: a report of potential self-harm and threats against police, knowledge of Case's mental health history, the sight of an empty holster suggesting a gun was somewhere in the house, and complete silence from Case despite extensive attempts to make contact. They argued that requiring officers to wait for absolute proof of injury before acting would defeat the entire purpose of the emergency aid exception. Most court observers predicted two possible outcomes. Either the Supreme Court would send the case back to Montana with instructions to apply the correct Brigham City Standard, or they would apply that standard themselves and rule on whether the entry was justified. The unanimous ruling breakdown. In this unanimous ruling issued today, the Supreme Court took the second path and went even further. Justice Ketanji Brown Jackson authored the opinion, joined by all 8 of her colleagues, including both the court's most conservative and most liberal members. They decided to apply the objectively reasonable standard themselves rather than sending the case back to Montana. And they concluded definitively that the officers acted properly. The Supreme Court held that police officers do not need probable cause to enter a home without a warrant when responding to a genuine emergency involving potential harm to an occupant. The court reaffirmed the Brigham City rule. Officers may enter if they have an objectively reasonable basis for believing that someone inside is seriously injured or facing imminent threat of such injury. This is neither the low bar of reasonable suspicion nor the high bar of probable cause. The court rejected 3 different arguments. First, they rejected Montana's use of the reasonable suspicion standard, calling it too vague and noting it was designed for street encounters, not home entries. Second, they rejected Case's argument that probable cause should be required for emergency entries, explaining that probable cause is tied to criminal investigations and doesn't translate well to non-criminal life-saving interventions. Justice Jackson wrote that the Fourth Amendment does not require police to stand by and do nothing in the face of imminent risk to human life. She emphasized that the test is objective, meaning it doesn't matter what the officers subjectively thought or intended. What matters is whether their belief that entry was necessary would be reasonable to an objective observer. Why the officers' entry was justified. The Supreme Court walked through the specific facts that made this entry objectively reasonable. First, officers were responding to a credible report from someone who personally knew Case and had just spoken with him. The ex-girlfriend expressed genuine concern about his mental state and potential for violence. While her memory of the exact words was imperfect, her emotional distress and fear were apparently real enough to prompt her to call police and accompany them to the scene. Second, multiple officers personally knew Trevor Case and were aware of his history of mental health issues and prior concerning interactions with law enforcement. This wasn't a situation where police were operating on a random tip about a stranger. They had contextual knowledge that made the report more credible. Third, officers observed an empty handgun holster visible through the window. This suggested that a firearm was somewhere in the residence, corroborating the ex-girlfriend's mention of a gun. The combination of a weapon being present and concerns about self-harm or violence created a heightened risk scenario. Fourth, despite 40 minutes of knocking, calling out, and shining lights through windows, Case gave no response whatsoever, The court found this silence significant. While citizens have a constitutional right not to answer their door for police, the lack of any response when officers are investigating a welfare check can contribute to reasonable concern that someone inside may be incapacitated or in distress. What this means for your rights. Going forward, law enforcement across America must apply this objectively reasonable standard when deciding whether to enter a home without a warrant in an emergency. This ruling doesn't give police unlimited authority. They can't enter your home just because they're curious or because they want to investigate potential criminal activity. The emergency aid exception only applies when officers genuinely and reasonably believe someone inside faces serious injury or imminent harm. However, the standard is also not as restrictive as requiring probable cause or proof of an actual emergency. Officers don't need to wait until they have certainty that someone is hurt. They don't need to exhaust every possible alternative before entering. And they don't need a judge's permission if they have objectively reasonable grounds to believe immediate entry is necessary to save a life. For homeowners, and especially gun owners, this creates a concerning gray area. What constitutes objectively reasonable will be decided on a case-by-case basis, and different courts may apply that standard differently. A report from an ex-partner with a grudge could potentially provide the basis for warrantless entry if officers find it credible. Mental health crises could routinely justify police entering homes. Critics of today's ruling argue that it gives too much discretion to officers and insufficient protection to the sanctity of the home. They point out that Case was shot by police who entered his house without permission, and now that entry has been ruled constitutional. The practical impact nationwide. This Supreme Court decision will have immediate effects on thousands of pending cases across federal and state courts. Any case where evidence was suppressed because a lower court found that officers lacked probable cause for an emergency entry will now need to be reconsidered under the objectively reasonable standard. Prosecutors will move to reinstate evidence in cases that were thrown out, and defendants who thought they had won suppression motions may find their convictions reinstated. Law enforcement agencies will update their training protocols to reflect this ruling. Officers will be taught that they don't need probable cause for emergency welfare checks, but they do need to be able to articulate specific, objective facts that made them believe someone was in danger. Departments will likely see an increase in warrantless entries as officers feel more confident that courts will uphold their decisions. Defense attorneys will need to adjust their strategies when challenging warrantless entries. Rather than arguing that probable cause was lacking, they'll need to attack whether a reasonable officer in that specific situation would have believed entry was necessary. This is a more difficult argument to win, because reasonableness is evaluated from the officer's perspective at the time, without the benefit of hindsight. Gun owners and mental health concerns. No doubt there will be significant fallout from this ruling within the gun rights community. Many Second Amendment advocates are deeply concerned that this decision creates a pathway for law enforcement to conduct warrantless searches of gun owners' homes under the guise of welfare checks. The scenario is easy to imagine. Someone reports that a gun owner made a concerning statement. Police arrive and claim they need to enter for safety reasons. And once inside, they seize firearms under red flag laws or other pretexts. This concern is heightened by the increasing prevalence of red flag laws, also called extreme risk protection orders, which allow courts to temporarily confiscate firearms from individuals deemed to pose a danger to themselves or others. Currently, 21 states and the District of Columbia have such laws. Critics argue that today's ruling could enable police to bypass the judicial process entirely by conducting emergency entries, discovering firearms, and seizing them without ever obtaining a proper warrant or court order. The mental health aspect is equally troubling. According to the National Institute of Mental Health, approximately 1 in 5 American adults experiences mental illness in a given year. That's roughly 50 million people. If police can enter homes without warrants whenever someone reports that a person with a mental health history might be in distress, millions of Americans could potentially be subject to warrantless searches based on nothing more than concern from a family member, neighbor, or acquaintance. So that's what happened in this critical case. If you found this breakdown valuable, hit that like button, drop a comment with your thoughts on this ruling, and subscribe for more coverage of Supreme Court decisions that directly impact your constitutional rights. Thanks for watching, and stay informed about the laws that govern your life.